Mr. Albrecht, please.
Thank you, Commissioner, for explaining your views after the judgment and listening to our points and answering some further questions. My first remark or also question would be with regard to now pursuing a new kind of arrangement, a new kind of adequacy arrangement. I asked myself really again and again since the judgment, how do you want to adopt a new decision which is meeting the demands of the court without being able, and you are not able, to change the US legislative framework very soon? I mean, it is very clear, the court has been very clear that the legislative arrangements in the United States are not allowing for an essentially equivalent or adequate protection. So what are we talking about? I mean, there won't be a decision, a new decision by the European Commission fixing that problems in due time. So I also don't think that I just question, and I would like to have further elaboration on how exactly you want to meet that demand and how do you want to meet these concerns raised by the court. But there's a next question, and that is why? Because I think that the ball is now in the court of the United States, and if they want their companies to have an arrangement as an adequacy arrangement which is a privileged access to the European market in comparison to all the others, because not having an adequacy rating doesn't mean that you can't access the European market. It's just another way. You already allowed that. But why should the European Commission deal with this issue now? Why shouldn't it be just the issue of the United States government to fix that, or of the respective companies to approach their government on changing the arrangement? I just question that, and I would like to have an elaboration on that. And of course we are talking also about the respect to courts this time and to this judgment. And I think it's perfectly right if Timothy Kirkhope questions, how will you assure that there won't be another decision which is in breach of the law, and that another long way of a citizen is needed to Luxembourg to get this done again? And how will you assure that it doesn't need to be the citizens fixing that, but in the future it is the Commission directly fixing it? I think that those questions need to be answered. But sorry, Chair, that I need another minute, because I want to point another point, which I think is important. The court referred to the revelations by Edward Snowden on the PRISM programme and other programmes, mass surveillance programmes, and therefore dismissed the adequate protection of the legal framework. Thereby the court said, first of all, the revelations are essentially true, and we take them, and there is a matter with mass surveillance systems. If that's the case, then I would like to see a reaction by the European Commission to that, which is, some parts of these revelations are referring to our own member states acting in the area of national security in breach of the Charter of Fundamental Rights. And I don't see why the European Commission doesn't take this serious and starts, even at least now, infringement procedures against those member states who obviously go beyond what is allowed in the area of national security and what should be covered by EU law, and what should be in the area of protection of fundamental rights of the European Union. At least I think that also in the area of national security, the common understanding of what is human rights should be applied. So I think that is one of the areas where you should get active with regard to this judgment. But also there's another one which is also cited in the judgment, a judgment of last year on the Data Retention Directive, which is clearly dismissing mass surveillance without any relation to risk or suspicion towards individuals, and still in all the member states in the area of EU law, e-privacy directive, member states are having these measures in place. So where's the European Commission enforcing this judgment and the previous one vis-à-vis the member states? And I would really like to have an answer to this question.